A custody modification can be filed anytime there is a material and substantial change in circumstances. Um, so, what does that mean? Well, a material and substantial change can be just about anything. It could be that one parent isn't taking all their visits. It could be that the kids are coming back from the other parent's house and now there are safety concerns. It could be, a change in the possession schedule is needed because the other parent took a new job and now they're not able to get the kids back and forth to school on time. The variety of reasons to file a modification are very wide and very diverse. It just has to be a material and substantial change. And the bar for meeting that definition in family court is pretty low. There are some reasons for a modification that we would tell you this doesn't meet the cost benefit analysis. A parent's medical insurance has gone up by $50 a month. It would take you a really long time to recoup the cost of starting a case at $50 a month. So sometimes the cost benefit analysis isn't there, but the only thing you have to be able to do for a modification would be a material and substantial change in the circumstances. The best time to request a modification is when you need it. There is something pressing going on that requires a change, and the other co-parent will not co-parent to the extent that you're hoping and agree to a change without having to go back to court. The other factor to consider in filing the modification is a cost benefit analysis. Does the cost of starting a case, is it justified by the result that you're going to get at the end of the case? Sometimes things have to accumulate over time before that cost benefit analysis indicates that it's time to start a case. We frequently talk to people that come in and are ready to start a case, and we tell them, you're just not there yet. We don't have what we need to start the case yet. So, do you need it? And does it make sense? Are you going to get your return on investment if you file it yet? Those are the two main things you need to consider when starting a case. There's always risk involved anytime you start a court case. So you have to know that if you go and you file your modification to get the change that you want, chances are the other party is also going to be like, you know what? I also want a modification, and here are the things I want to change. So it's very rare that we wouldn't have competing cases, right? So we file our petition to modify, opposing party's going to file their counter petition to modify, and now the court is looking at the relief that both parties want. So yes, there is always risk in going to family court, and the risk in filing a modification is that the other side is also going to file a modification to change the things they want changed in the order. Starting a modification is really easy. You're going to find an attorney that you feel comfortable working with, and they're going to file your petition to modify, and then the case is open. There's typically a temporary orders hearing in the first 4 to 6 weeks, depending on resets in the beginning. And then the case is running until we enter a final order. So it's a lot like the same process that was used to get the original order. So we file the case, we have temporary orders, and then sometime down the road, we're going to get to a final agreement. So if you have questions about modifications, feel free to give us a call. We'd love to help you with that.